All right. So you can go on with the intro, with your intro. If you
Oh,
want to
okay.
add
Okay. So
anything.
I didn't know how you were going to chop it up. Okay. Yes, I am an attorney, and one of my areas of expertise is constitutional law. And another area of interest is critical race theory. I taught law for many years, and I'm also a journalist with an interest in racial justice issues.
Wonderful, wonderful. So, since I invited you to specifically talk about the affirmative action ruling, can you just briefly tell us the background of affirmative action as it relates to how it got to this case and this ruling with the Supreme Court?
Yes, actually. So, one of the things that I really want people to understand is a lot of people think that affirmative action is something new. Well, actually, that's not true.
Mhm.
Affirmative action is actually pretty old. It's over 60 years old. It goes all the way back to the 1960s and John F. Kennedy. There were programs before that that encouraged the government to do certain things, going all the way back, in fact, to Truman. But the language, Kennedy issued an executive order that said, I direct the federal government to take affirmative action to ensure that there's no discrimination in race, creed, or color. And so that's where it takes off from, that language, affirmative action. Kennedy started it, and his successor, Johnson, doubled down on it. And that is how we got to the genesis of affirmative action. And as you can see, when it started, it began in the federal workplace, and then it spread out into the private sector, where you might see, if you go to apply for a job, they might say an affirmative action employer or something like that. But then it also spread into college admissions, especially when students protested a lot after Dr. King died. That pushed a lot of universities to look at their policies and to try to take a look at what they could do to diversify.
So, when you say that so it started with Kennedy, and then when Johnson came in, did he not want it anymore, or was
Oh
he
no,
not?
he doubled down on it. No, he Kennedy signed an executive order. Johnson signed a similar executive order, and
Oh,
believe it or not, even Nixon kept it going. So it, for a minute, believe it or not, it was actually this bipartisan idea that largely, again, in response, this was not some sort of, largesse or something. This was in response to Black folks protesting and voting and doing other things. And that is what that was born out of.
okay. So was this, you think it was specifically put in place for melanated people, or for
Absolutely, because that's
us?
what it says. It said race, creed, color. It didn't say religion. It didn't say gender. It was specifically for race in the very beginning.
Hmm. Is that because there was so much discrimination going on that it was?
Absolutely. And that's why I know that's not the reason why I'm here on the show, but one of the other things I do is to teach African American history. And so of course I'm appalled at things that are going on in Florida and elsewhere, where, they want to not teach our history, because yes, this was in large part a response to understanding that there had been so much blatant racism, that one of the only ways to address it was to say, okay, we have to do something. And this is where we get into what a lot of scholars call race neutral versus race blind versus race conscious, right? So if you have, for instance, a race blind policy,
Mhm.
right? That would mean, oh, I'm just going to take everybody, and oh, we don't see color. So basically, you're not even acknowledging, for example, that some of the students in your admissions pile may have gone to worse K through 12 schools, et cetera, et cetera. Race neutral is, we're going to take everyone, at this level, similar to race conscious, around race blind, but they're trying to be a little more benign about it. But then you also have race conscious, And so when you look to something like critical race theory, what they say is, well, if the harm was racially motivated, then the remedy has to be too.